All right, so this is chapter 2, which is contract basics. And in our previous chapter, we, laid the foundation, for the legal landscape of contract law. We discussed where it comes from, how to distinguish it from common law and the UCC or the Uniform Commercial Code, how to read the cases, and how to begin your legal research. In this chapter, we're going to move closer to the agreement itself. Okay. So the central question here is simple, to state, but it does become kind of complicated to answer. And that is, what makes a promise legally enforceable? People make promises every single day. A friend will say things like, I'll call you later. A parent promises to take a child to the movies. A coworker promises to bring coffee to a meeting. Those statements may be meaningful socially, but not every promise is a contract. So contract law does not enforce every expectation or every disappointment. But a legally enforceable contract generally it requires an agreement, which is going to have an exchange of value, and other legal requirements that we're going to discuss throughout this chapter. We're going to look at offer, acceptance, consideration, mutual assent, capacity, legality, legal form, all of those things. We'll also learn the vocabulary that's used to describe the people that are involved in a contract and the different ways an agreement can be classified. Those classifications matter because they help us to describe how a contract was formed. How was it communicated? Whether performance, remains due, whether the contract can even be enforced. An agreement may be unilateral, it may be bilateral, it may be expressed, it may be implied, it may be executory, it may be executed, it may be void, voidable, or unenforceable, it may be formal or informal. It may be written, it may be oral. One agreement can belong to several of these different categories at the same time too. So as we kind of work through the concepts, just remember that contract law is practical. The examples in this chapter will include purchases, services, rewards, your everyday kind of business transactions, and your written agreements. Okay, the goal is not simply to memorize definitions. The goal is to use definitions to analyze real situations carefully and accurately. So hopefully by the end of the lecture, you'll be able to look at basic fact patterns, identify, the contract elements, apply the appropriate terminology, and even classify the agreement in several different ways. All right, so this slide gives us our roadmap for this chapter. We're going to begin by defining a contract. Then we're going to develop the vocabulary and the analytical tools that are needed to determine whether or not a particular promise or an agreement is legally enforceable. First, we're going to define a contract, and we're going to go into this in way more detail, but a contract is generally an agreement between the parties for a value that is legally enforceable. This definition contains several ideas that each require attention. There must be parties, there must be an agreement, there must be value that's exchanged or promised, and the law must recognize that the agreement is enforceable. Okay? Next, we're going to learn the languages of contracting, or I guess not the languages, but the language of contracting. Um, Legal vocabulary helps us to describe the parties and their actions precisely. So the person making an offer is the offeror. The person receiving the offer is the offeree. The person that's making the promise is the promisor, and the person to whom a promise is made is the promisee. And those terms may sound, technical at first, but they become useful when you're analyzing a detailed fact pattern or you're drafting a legal document. Third, we're going to review the general elements of a contract. These include offer, acceptance, consideration, mutual assent, capacity, legality, and sometimes a required legal form. Now, you should think of these as like a preliminary checklist, okay? Not every dispute requires the same depth of analysis for every element, all right? But every contract problem should prompt you to at least ask whether the essential requirements are present. Okay. Fourth is we're going to classify the contracts. And again, classification is just the way of describing the legal nature of an agreement. We're going to discuss bilateral and unilateral contracts, express and implied, executed and executory, void, voidable, and unenforceable, and even formal and informal contracts. And then we're going to apply these to real life transactions. Now, throughout the chapter, we're going to use examples that will hopefully make the law approachable. And I say this because if you've heard me talk about this before, then you know that the only class that made me want to drop out of law school was contracts. Okay? It about broke me. But I think it has everything to do with the fact that it's a different type of learning. So I'm going to do my best to make it so that it's approachable, it's understandable, and you're not going to want to drop out. Um, Anyhow, and the guiding question, as you see, is what makes a promise legally enforceable? So kind of keep that in the back of your mind as we work through every term and every example. Now, this chapter has 5 learning objectives. The first is to master key terms that are used in the contracting process. So, accurate terminology matters because your legal analysis depends on precision. If you confuse an offeror with an offeree or a promisor with a promisee, it becomes difficult to explain what happened in a transaction. Okay? The second objective is to recognize the general elements of a contract. Again, you're going to learn how offer, acceptance, consideration, mutual assent, capacity, legality, and legal form all work together. All right, now later chapters are going to explore those concepts in greater detail, but we're going to start with the foundation here. So just humor me. The third objective is to describe those principal classifications of contracts. Again, those are going to help you to identify whether an agreement is based on exchange promises, requested performance, are they express words, or is it implied conduct? Are the duties completed, or do we still have future duties to, still need to be handled? And what are the particular rules of enforceability? All right. The fourth objective is to distinguish implied in fact contracts from quasi contracts or quasi obligations. This is a very subtle but an important distinction. An implied in fact contract is an actual agreement that gets inferred from conduct and circumstances. A quasi contract is not an actual contract, but it is an obligation that's imposed by a court to prevent unjust enrichment. Okay. And the fifth objective is to be able to differentiate between void, voidable, and unenforceable agreements. So those terms are often used very loosely in ordinary conversation, but they have very different legal meanings. Okay. A void agreement has no legal effect. A voidable agreement may be rejected or affirmed by a party who has the legal right to do so. Okay. And an unenforceable agreement may exist, but a court will not enforce it under the circumstances. So as you listen, I want you to focus on understanding each term in context. You know, contract law is, it's not only vocabulary, and I promise you it's a lot of vocabulary, but here's where we're going to be digging in and applying that vocabulary to the facts. All right, so ordinarily I would be doing this in person, but nonetheless, let's talk about a scenario that's a little more common. I was going to build off of last week, but I decided this would probably make it easier because it's a more modern transaction, okay, which is a sale that's arranged through an online marketplace. So imagine that Jordan puts up their laptop for sale on Facebook Marketplace, and the listing states that the price is $600. Casey sees that the listing is something up their alley, sends Jordan a message, says, I'll take it for $600. I'll pick it up tomorrow by 5. Jordan replies, great, see you then. Later that day, another buyer comes along and says, look, I'll give you $750 for the laptop. And Jordan messages Casey and says, sorry, I decided to sell it to somebody else. Okay. Now, at first thought, this might seem like a simple question of fairness. Casey may feel that Jordan made a commitment and should keep it. Jordan may feel that the laptop is still their property and Jordan's free to accept a better offer. But contract law requires us to slow down and identify the legal issues before we reach a conclusion. Okay, so the first question is, whether Jordan's original listing was an offer. And in many situations, advertisements are, well, and listings, I should say, are treated as invitations for others to make offers, rather than treating them as offers themselves. Okay, so a listing may provide information about an item and its price without actually committing to the seller to sell, basically to every single person who responds. Okay, so the exact wording of the listing is what matters. A listing that says something like first come, first serve, price negotiable, for sale, message me with offers. Those tend to affect how a reasonable person interprets the communication. The next question is whether Casey made an offer. Casey's message is specific. Casey identifies the item, accepts the stated price, and proposes a time for pickup. Okay, so a court might view that message as an offer to buy the laptop for, $600 based on those stated terms. But we still have to examine Jordan's response. So Jordan says, okay, cool, see you then, right? Does that statement objectively communicate an acceptance? It might. It depends. That's the law school answer. It depends. So a reasonable person could interpret that message as agreement to sell the laptop to Casey, for $600. But the analysis may depend on additional facts. Like, did Jordan say that the item was pending after responding? Did either party discuss a payment method? Was the laptop being held for Casey? Like, did Casey send a deposit? Did the parties have a history of buying and selling items under similar arrangements with one another? Did Jordan communicate any kind of condition, such as like, as long as no one else arrives, first with the cash? Okay, so this scenario right here allows us to identify several contract elements. We can look for an offer, acceptance, consideration, and mutual assent. Okay, consideration has to be present, or I guess it may be present. It has to be present for it to be an enforceable contract. But in this particular case, it may be present because Jordan is promising to transfer ownership of the laptop, and Casey's promising to pay, $600. Mutual assent, though, depends on whether the parties' words and conduct objectively show an agreement on the material terms. Okay, so we can kind of begin using some of our vocabulary from this chapter. Jordan may be considered the offeror if Jordan's listing is treated as an offer. In that case, Casey would be the offeree. Okay. In the alternative, though, Casey may be the offeror if Casey's message is treated as an offer to purchase. All right. The labels depend on how the communications are classified, and that's helpful when it comes to just basically giving you a working example so that you can see that the facts and the sequence of communications do matter. Okay. Now, ordinarily, we'd talk about it a little more in detail, but again, we'll pick this up next week. But I do want to say, just remember that modern technology does change the way that the parties communicate, but it doesn't eliminate your basic contract questions. We're still going to ask whether or not a party made a definite offer, whether or not the other party accepted, whether the parties exchange value, and whether or not their words and conduct show this mutual assent. So, what is a contract? A contract is generally an agreement between the parties. It is supported by value, and it's something that the law will enforce. And that definition is very simple, but each phrase contains a very important legal idea. Okay. First, a contract involves an agreement between the parties. The parties may be individuals, businesses, organizations, government entities, whatever. All right. An agreement can be written, it can be oral, it can be inferred by conduct. It just depends on the circumstances and the legal requirements. Second is the agreement must be supported by value. So in contract law, value is often described as consideration, and consideration is what we call the bargain for exchange. It is what one party gives, promises, does, or refrains from doing in exchange for the other party's promise or their performance. Okay? Consideration does not have to be, equal in terms of economic value, but it does have to be considered legally sufficient. Okay? And the third is that the agreement must be legally enforceable. All right? So not every promise satisfies that standard. A court is going to look at and determine whether there was a real offer, whether there was a real acceptance, whether the parties agreed on material terms, whether the parties had legal capacity, whether the transaction was lawful, whether the law, required a specific form, like did it require writing? Okay. Courts generally use an objective viewpoint in deciding whether or not a case or a contract exists, rather. This means that the court does focus on things like outward expressions, what the parties said, what the parties did. Okay. And they're going to do that rather than, some sort of secret, unexpressed intentions. If someone internally thinks, like, I was only joking, but makes a statement that a reasonable person would understand as a serious offer, then the court may focus and likely will focus on the objective meaning of the statement. Okay. For example, let's say that you have a homeowner who says to a contractor, I will pay you $10,000 to renovate my kitchen according to the attached, specifications. Contractor replies, I accept and will begin work on June 1st. Okay, so a court would examine the words, the documents, the conduct, and the circumstances to decide whether or not the parties objectively manifested an agreement. All right, the court would not ordinarily base its decision on one party's like unspoken belief that this agreement was just merely tentative. Okay, so when analyzing a contract, you're going to ask multiple questions like, did the parties reach an agreement? What is the subject matter? What rights and obligations did the agreement create? Did the parties perform those obligations? If someone failed to perform, what remedy might be available? And those are the questions that we'll also come back to throughout, the duration of this course. So legal terminology helps us describe the contracting process accurately. And I've already gone over these, but I want to just make sure that we fully understand what it is that they do. Okay. So we're going to start with the parties to an offer. So the offeror is a person who is making an offer. All right. An offer is a proposal that is made with the purpose of obtaining acceptance and creating a contract. So if Riley says, I will sell you my bike for $200, Riley is the offeror. Okay. The offeree is the person to whom the offer is made. So like in our bike example, the person receiving Riley's proposal is the offeree. And the offeree has the power to accept it, reject it. They can make a counter offer. And sometimes they can just simply allow the offer to expire. Okay. A promisor is the person who makes a promise. A promisee is the person to whom the promise is made. So, like in a bilateral contract, each party is often both the promisor and the promisee because each is making a promise to the other. All right. So, for example, let's say that you have an employment agreement. The employee promises to perform work, and the employer promises to pay compensation. So, each party is making and receiving promises. Okay. You might also see down here at the bottom where it has the informal, shorthand. K is what we use for contracts. P is the Greek letter for pi, which tends to get used for plaintiff. And then D, or using the Greek letter delta, gets used for the defendant. Okay. Just telling you this because you will see it in some places, but not a whole lot. But it can be useful when you are trying to take notes or do like informal outlines or something like that. But it should not be used in formal legal documents or contracts or even in any kind of like client communications unless the context actually allows it. Okay. Um, the term legalese, it refers to legal jargon. So, some legal terminology is absolutely necessary because it conveys a very specific legal meaning. But the goal is not to avoid like every technical term. The goal is to understand the terms well enough to use them as they are supposed to be, and then to clearly explain them to a client or a colleague or a judge or something like that. So, as you build your vocabulary, kind of practice identifying the parties in the examples. Who made the offer, who received it, who promised what, who was supposed to perform. Again, those are going to help you, take what might even be very complex fact patterns and organize them much more easily. So here we have the general elements of a contract. Think of these elements as your checklist for your preliminary analysis, okay? Later chapters, again, they're going to explore every single one of these things much more deeply. But you should still kind of become at least, familiar with the role that each one plays. The first element is the offer. And an offer is a communication, proposing a bargain and inviting acceptance. Okay, so a valid offer must be sufficiently definite so that the other party can understand what is proposed. Okay, it must show an objective intent to be bound if it gets accepted. All right, the second element is acceptance. Acceptance is the offeree's manifestation of assent to the offer. All right. And I know, again, all of this sounds like gobbledygook probably, but I promise it's all going to make sense, especially as we kind of dive in. Um, so the manner of acceptance depends on the terms of the offer and the governing law. Sometimes acceptance is just a promise, sometimes it's performance. Sometimes it can be done, electronically, like through a click or a signature, or some other kind of manifestation of agreement. The third element is consideration. And again, consideration is that value that gets exchanged for a promise or performance. So it can involve money, goods, services, a promise to act, or a promise to refrain from acting. For example, let's say that there's a car that's being sold. The seller's promise to transfer the car and the buyer's promise to pay would be the consideration for each in a bilateral contract. All right. Um, in a unilateral contract, it would be the seller's promise to transfer the car and the buyer providing the money, to purchase it. Um, the fourth element is mutual assent, and that means that the parties objectively agree on the material terms of this bargain. All right, it is sometimes called the meeting of the minds, but the courts don't like look for like identical private thoughts or anything like that. They look to whether the people, like the parties, what were their words, what were their what kind of conduct did they display? Does either of those, demonstrate that an agreement existed? Okay. The fifth element is capacity. Capacity refers to the party's legal ability to understand and enter a contract. So issues of capacity, they can arise with minors, intoxicated individuals, persons with certain mental impairments, and like others whose ability to make a legally binding decision is limited. The sixth is legality. So the contract must involve lawful subject matter and a lawful purpose. Courts generally will not enforce agreements that require illegal conduct or violate public policy. Okay. The seventh is legal form, and some agreements have to meet statutory form requirements, such as being in writing and signed. All right. Those requirements are often associated with what's known as the statute of frauds, and we'll talk about that in more detail too. Not every contract has to be written, but there are certain categories that may require, written evidence in order to be enforceable. So when you analyze a fact pattern, move through the elements systematically. Identify, the proposed exchange, identify the parties' words and their conduct. Ask whether value was exchanged. Ask whether the parties had capacity and whether or not the subject matter was lawful. And then also, again, ask whether the law requires a writing or some other form. All right, so offer and acceptance are the beginning of contract formation. An offer is a proposal that invites another person to accept and to form a contract. Acceptance is the offeree's objective manifestation of agreement to the offer. So, Avery says to Morgan, I will sell you my laptop for $700. You may accept by sending me a message by Friday. All right, so Avery has made a proposal that identifies the price, the item, and the method and deadline for acceptance. So if Morgan responds by Friday, I agree to buy your laptop for $700, then Morgan has accepted the offer. Okay, so an offer should be distinguished from what's considered preliminary negotiations. So a statement like, I might sell you my laptop for $700, that can invite discussion that may not be definite enough to be an offer. Okay, likewise, an ad for something is treated usually as an invitation for customers to make offers rather than a binding offer itself. So the law is going to look at the language and the context. Okay. Now, acceptance generally has to correspond to the offer. So if Morgan replies, I accept, but only if you include a printer, Morgan may not have accepted the original offer. Instead, it may be looked at as having made a counteroffer. And a counteroffer is a new proposal that rejects or changes the original offer. All right. The timing and the method of acceptance can also matter. So an offeror may specify how acceptance must be communicated. So if the offer says you may only accept by signing this agreement, then an oral statement may be ineffective. If the offer invites acceptance by performance, then beginning or completing performance may have legal significance. Okay. The key is objective assent. Courts ask whether parties' outward words and conduct show that they agreed to this same bargain. Okay, and again, we're going to talk about it in way more detail, but just remember that the offer begins the proposed exchange. The acceptance completes the necessary agreement when it is properly, communicated back or performed. All right, consideration and mutual assent are closely connected to the idea that contracts are bargain for agreements. Consideration is the value that's exchanged by the parties. It is sometimes described as the price of the promise. So the question is not whether the bargain was wise or unequal. Courts generally do not evaluate whether someone made a good deal. Instead, courts ask whether the parties exchanged something of legal value. For example, if a homeowner promises to pay a landscaper $2,000 to install a garden, the homeowner's promise to pay is their consideration. The landscaper's promise is to perform the work. Okay. The landscaper's promise to perform is their consideration in exchange for the homeowner's promise to pay. Okay. Consideration can involve a promise, an act, a forbearance, or a transfer of property. Now, a forbearance is an agreement to refrain from doing something that one has the legal right to do. For example, a person might promise not to pursue legal action in exchange for a settlement payment. So the promise to refrain from filing suit can be consideration. Okay. Mutual assent means that the parties have objectively agreed to the terms of the bargain. Courts will examine communications, documents, signatures, conduct, customs, basically the totality of the circumstances. All right. Mutual assent does not require perfect agreement about every imaginable detail, but the parties do have to agree on material terms. Okay, so imagine that a business owner says, hey, I need you to design a logo. Designer's like, cool, I can do that. They have not necessarily formed a complete contract. You have a lot of important questions that remain open. What's the price? When is payment due? What work is included? When is the deadline? Who owns the final design? Now, in contrast, if the business owner says, look, I need you to design 3 logo options for me by October 1st, and I'll pay you $1,000 with payment due upon delivery, and the designer agrees, then mutual assent is going to be easier to identify. All right. The objective approach matters again because if both parties act as though they have an agreement, they exchange drafts, they begin performance, and they make payments, then their conduct is likely going to support a finding of mutual assent, even if the agreement is not perfectly written. Capacity, legality, and legal form address whether an otherwise apparent agreement can be enforced. Okay. Capacity refers to the legal ability to enter into a contract, and a person has to have sufficient understanding of the nature and the consequences of this transaction. Okay. Capacity issues commonly come up in matters that involve minors. All right. In many circumstances, a minor has the power to disaffirm or reject a contract. And we'll talk about that in way more detail. Capacity can also be affected by things like intoxication, mental incapacity, and other circumstances that prevent a person from understanding the transaction. Now, legality means the contract's purpose, and the subject matter has to be lawful. So, courts will generally not enforce agreements to commit crimes, evade legal duties, or engage in conduct that is prohibited by law or public policy. For example, you cannot enter into a deal to buy a pound of marijuana and go to the court and ask for them to enforce that contract. If an illegal activity is just that, then your contract regarding it is going to be usually void and or unenforceable. The law isn't going to reward parties for entering into bargains that require unlawful conduct. Okay, long story short. Legal form concerns any kind of statutory or procedural requirements for certain transactions. So the statute of frauds is a category of statutes that require certain agreements to be evidenced by, a writing that is signed by the party against whom enforcement is sought, which means you want both parties because enforcement can be asked for on both sides. Um, the purpose is to reduce fraud and to provide reliable evidence of important agreements, essentially. This came over from England, by the way, from 1677. And not it shows that not every contract has to be in writing. Like your everyday agreements, including like purchases and service agreements, for most ordinary things can be oral or implied. But there are certain transactions that are important enough that the law does require written proof in order to get it enforced. The exact categories and the rules do vary by jurisdiction. So make sure that, when you're actually working on a case that involves a contract, to research any kind of governing statutes and cases. And a useful habit is to ask three questions whenever you see a contract problem involving this. And that is like, did each party have legal capacity? Is the bargain lawful? And does the law require a specific form, such as it has to be in writing? Those questions help you to identify any potential enforceability issues before assuming that the agreement is just going to be upheld. Now, ordinarily, we would stop and talk about this after a poll, but we're just going to move forward. As you can see, it asks whether contracts should be required to be in writing in order to be legally enforceable. Okay. And you have a choice. Yes, written proof creates clarity, which is absolutely true. It really does. But you got no. Daily life requires flexibility, and there's definitely truth to that as well. There are strong arguments in favor of requiring written contracts. A written agreement can clarify the parties' obligations. It can identify the subject matter, the price, the deadlines, the conditions, the warranties, remedies, all of those things. So written contracts reduce the risk that parties will remember conversations differently because it happens. All right. They may also make disputes easier to resolve because the court has a document to interpret. Okay, so written agreements can be especially important where transactions involve like a substantial amount of money, long-term obligations, real estate, intellectual property, business ownership, anything that has significant risk. All right, they can help the parties to anticipate problems before they occur. All right, there's also strong arguments against requiring every contract to be in writing. And that's because much of daily commerce depends on quick and formal agreements. when you order food in a restaurant, when you purchase an item at a store, when you pay for a ride, when you hire somebody for a small task. It would be awkward and grossly inefficient to create a formal written contract every single time. The law recognizes that people can form enforceable agreements through oral communications and conduct. So the statute of frauds it represents a compromise. Okay? It doesn't require that all contracts be written. Instead, it just requires the writing for the certain categories of agreements where the risk of fraud, misunderstanding and substantial loss is particularly significant. Okay? Um, so the lesson here essentially is that form matters, but form is not the whole of contract law. A written contract or a written document, it does give you powerful evidence of an agreement, but at the same time, a good majority of our contracts arise from spoken words and conduct. Contracts can be classified in a few different ways, and the classification is going to help the lawyers and the courts and the parties describe how an agreement was formed and what legal consequences follow. Okay, so a contract may be bilateral or unilateral. That classification focuses on whether promises are exchanged or whether a promise is accepted through performance. A contract can be express or implied. That classification focuses on whether the agreement is stated directly in words or is it inferred from the parties' conducts and the circumstances. A contract may be executed or executory. That classification focuses on performance. So an executed contract has been fully performed. An executory contract still has future duties remaining. A contract may be void, voidable, or unenforceable. That classification focuses on the legal effect and enforceability. And these terms have distinct meanings and should never be used interchangeably. And again, we'll talk about those in way more detail. A contract can be formal or informal, and that classification focuses on whether or not any kind of special legal form is required, or is there like a ceremonial requirement that is necessary. But the overall gist is that a single contract can have multiple classifications. All right. Consider a written agreement in which, you're selling a car and you promise to do it next week and the buyer promises to pay at delivery. The agreement may be bilateral because maybe each promised, to promise something like, I promise to not sell it so long as you promise to be here with the money. All right. If both promises, they've exchanged something. It may be expressed because the terms are stated in writing. It may be executory because performance now remains due. It may be informal in the sense that it doesn't require like any kind of historic formalities like a seal or something like that. And it may be enforceable, if all legal requirements are satisfied. So don't like think of classifications as like competing labels. They answer different questions about the same agreement. A bilateral contract is formed through an exchange of promises. Each party is going to promise to do something for the other. The moment the promises are properly exchanged, the contract is generally binding, even though performance may not occur until much later. For example, a web designer promises to create a website for a business owner by October 1st. All right, the business owner promises to pay $2,000 when the work is complete, right? Um, the designer's promise is the consideration for the owner's promise, and the owner's promise is consideration for the designer's promise. That's a bilateral contract. I promise to pay you $500 if you promise to be here on Friday to paint my shutters. As long as you promise and I promise, it's a bilateral contract. All right. A unilateral contract involves a promise on one side that is accepted by performance rather than a return promise. Classic example is a reward. So, like a person says, I'll pay $500 to anyone who returns my lost dog. All right. The offeror is not seeking a promise from the public that someone will search. The offeror is seeking performance, and that is the return of the dog. Okay. Um, I promise to pay you $500 if you paint my shutters in the next 2 weeks. You don't have to. But if you show up and paint my shutters in the next 2 weeks, then I have to pay you the $500. Okay. In a unilateral contract, the requested act is acceptance. So questions may arise about when performance begins. You know, actually bigger than that, like even whether like the offer can be revoked and whether or not the person performing has satisfied like the conditions of the offer. Those questions then can become very complicated. And again, we'll talk about that in much more detail later on, but I did want to throw it out there. But it's important not to assume that every statement, like offering money for an act, is going to create an enforceable unilateral contract. The offer has to be what's considered sufficiently definite. All right, it has to be communicated and it has to be lawful. So the person that's claiming acceptance must perform the requested conditions. All right. To classify an agreement, you ask whether or not the party made a promise to the other. If so, bilateral contract analysis is likely appropriate. Ask instead whether or not one party offered a promise in exchange for an act. If so, unilateral contract analysis is likely appropriate. But remember that a lot of ordinary business agreements are bilateral. Employment agreements, sales contracts, leases, service agreements, settlement agreements, they all involve mutual promises, re- rewards, contests. Certain performance-based offers are common in terms, of the unilateral contracts. An express contract is one whose terms are stated by the parties. So the agreement can be written or oral. What makes it express is that the parties communicate the terms directly. For example, homeowner says, "Look, I will pay you $300 to mow my lawn every week for the next month." All right, landscaper says, "Okay, I agree." That's an express agreement because the parties have stated the essential terms. Now, an implied in fact contract is an actual agreement that gets inferred by the parties' conduct, the circumstances, the relationship. The parties may never actually state like the full terms out loud, but their behavior objectively indicates that there's a mutual agreement. For example, customer who enters a restaurant, they order a meal, they eat the meal, they receive a bill. The customer may not sign a written contract or say every term explicitly, but the conduct of the parties is going to demonstrate an agreement. The restaurant provides food and service, and the customer is expected to pay the stated or reasonable price. Okay, this is often described as an implied in fact contract. All right, now an implied in law contract is different. It is not a contract that is based on actual assent. Instead, this is an obligation that is that's imposed by a court to prevent unjust enrichment. This is also commonly called the quasi contract. So the law may require payment even when the parties like did not form a true contract. For example, a person receives, necessary medical services while they're unconscious, right? The patient did not make an express promise. They didn't even engage in any kind of conduct that demonstrates actual agreement. But the court can impose an obligation to pay the reasonable value of the services received because it would be unjust for the patient to retain the benefits without the compensation. And that distinction is important. An implied in fact contract rests on an actual agreement that's inferred from conduct. A quasi contract rests on fairness and prevention of unjust enrichment, not on an actual agreement. A quasi contract is an obligation that's imposed by law to prevent unjust enrichment. Again, that phrase can be confusing because a quasi contract is not a true contract in the ordinary sense. The parties have not exchanged promises or agreed to terms. Instead, the courts have created an obligation because one party did receive a benefit that would be unfair to keep without payment. All right. Unjust enrichment occurs when a person receives money, property, services, or some other kind of benefit under circumstances in which equity is going to require compensation. All right. So the law asks whether the recipient was enriched, whether the enrichment came at another person's expense, and whether or not it would be unjust for the recipient to retain the benefit without paying. Quantum meruit is a related term. It means as much as deserved, okay? And generally refers to reasonable compensation for the benefits or the services that were provided. Um, so, like a party that's seeking recovery in quantum meruit is usually not enforcing a negotiated contract price. Instead, the party is seeking a reasonable value of the benefit that they conferred. All right. Let's say that you have a contractor who, mistakenly improves the wrong property, but the property owner knows about the work, they accept the benefit, and they say nothing. Depending on the facts and the jurisdiction, the contractor then can seek restitution or quantum meruit in order to avoid unjust enrichment. The issue is not necessarily whether a contract existed. The issue is whether the owner should be allowed to retain a benefit without paying a reasonable amount. All right. Quasi contract remedies are equitable in nature. They are designed to prevent the unfair retention of benefits. They don't allow a party to simply rewrite a bad bargain or, to obtain payment where a valid contract governs this same subject matter. And in a lot of jurisdictions, the existence of an enforceable express contract can limit quasi contract recovery because the contract itself defines the party's rights. Again, I know I'm saying a lot and it's probably not all sinking in, but we will get to it every ounce in detail. The practical lesson here, though, separated out into the questions. Was there an actual contract, either express or implied? Implied, in fact, I should say. If not, did one party receive a benefit that would make non payment unjust? That's the pathway to quasi contract analysis. The terms executed and executory describe the stage of performance. So, an executed contract is a contract whose terms have been fully performed. So, if both parties have completed all of their material obligations, the contract is executed. For example, a customer buys a book at a bookstore. They pay the price, they receive the book. The transaction is generally executed because each party has performed. Okay. An executory contract is a contract in which some performance remains due. The agreement is still binding, but one or both parties must perform future obligations. Okay. A signed lease, like before the tenant moves, or before they move in, we should say, is executory. The landlord still has to provide, possession, and the tenant still has to pay rent. A contract for a contractor to build a deck, like next month, is executory because the contractor has not yet built the deck and the homeowner has not yet paid. All right, so be careful with the word executed. In legal practice, executed can also mean signed. Someone may sign, the parties executed the agreement on Monday. That means they signed it. The use of the word does not necessarily mean that all contractual duties have been performed. So remember, context matters. Um, the important distinction is basically between formation and performance. A contract can be fully formed and legally binding, even though it's executory. The fact that the duties remain in the future does not make the agreement incomplete or unenforceable. So when you analyze a contract, ask whether the parties have fully performed. If the answer is yes, then the contract is executed. If the parties have duties that remain, it's executory. And that classification can matter in contexts that involve breaches, remedies, assignments, contract administration, and even bankruptcy. Void, voidable, and unenforceable are different legal concepts, and it's very important that you use them accurately. A void contract has no legal effect. It is treated as though it never became legally valid. Okay, so agreements involving illegal subject matter are very common examples. If parties enter into an agreement requiring criminal conduct, a court is generally not going to enforce it. The agreement is void because the law will not recognize it as a valid legal obligation. Okay? A voidable contract is one that may be avoided or canceled by a party who has a legal right to do so. Now, until that party disaffirms the contract, the agreement can remain in effect. Capacity issues often create voidable contracts. For example, a minor may have the right to disaffirm certain contracts. A person whose capacity was impaired by intoxication or mental capacity, they have the right to avoid a contract under certain circumstances as well. Fraud, misrepresentation, duress. They can also, undue influence, I should add that too. They can also create voidable contracts. So if one party was induced to enter into the agreement through deception or improper pressure, then the party may have the right to rescind or to avoid the contract. And boy, do I have a whole example in my own life that I can tell you guys about if you remind me. Um, it's an interesting one. Um, an unenforceable contract is an agreement that may otherwise exist, but it can't be enforced in court because of a legal defense or rule. So the statute of frauds is our most common example for this. If a statute requires that a particular contract has to be in writing and the required writing is absent, then the agreement may be unenforceable. So the parties may have actually agreed, but the court may refuse to enforce the agreement because the legal form requirement was not satisfied. All right. So these classifications, they all have different consequences. A void agreement has no legal existence. The voidable agreement gives one party the choice to either affirm or disaffirm. And then the unenforceable agreement can involve a real agreement, but it lacks the legal conditions necessary for the court to enforce. All right, so in this particular case, when evaluating, ask whether the problem goes to the existence of a contract, the ability of one party to avoid it, or to the ability of the court to enforce it. That distinction often determines the most appropriate remedy and the actual legal argument. The final classification is your formal and informal. Historically speaking, common law recognized formal contracts that required particular like ceremonial requirements, like the seal, which could, be an imprint, a wax, or, other kind of symbol of authenticity and authority. The formalities had special legal significance in earlier systems. Modern contract law is generally less formal. So most agreements are informal contracts. An informal contract can be written, it can be oral, it can be implied by conduct. The focus is ordinarily on whether the parties objectively manifested agreement and satisfied the legal elements of a contract rather than whether or not they followed like an elaborate ceremony to execute the contract. Um, the some transactions, still require specific form. Real estate transfers, certain consumer disclosures, wills, guarantees, other kinds of legally significant instruments, they may require writings, signatures, witnesses, notarization, other formalities. Okay. The exact requirement depends on the law that is governing the transaction. Now, the word informal does not mean casual or unimportant. You can have a multi-million dollar business agreement that can be an informal contract if it does not require a special formal contract form. Okay. Likewise, an oral agreement can be legally enforceable if it satisfies the elements of contract formation and doesn't fall within a statute requiring a writing. Okay. So your takeaway here is just to distinguish a legal requirement, from a best practice. A written contract may not be always legally required, but it is often the less, yeah, we'll say it's the best way, I would say, in terms of business practice. It does help clarify the terms, it does help to reduce misunderstandings, it allocates risk, and it absolutely preserves evidence of an agreement. Now, let's apply the classifications to a real estate transaction. Buyer and seller, they sign an agreement for the sale of home. The buyer is going to pay closing next month, seller will transfer ownership at closing. All right. This is an express contract because the terms are stated in a signed writing. The parties have communicated their agreement directly through this document. All right. It's also a bilateral contract because each party has exchanged a promise. The seller promises to transfer the property, and the buyer promises to pay the purchase price. Okay. Neither party is merely promising to pay for an act that hasn't begun. Instead, each party has made a reciprocal promise. All right. Third is that the contract is executory because future performance still remains to be completed. The buyer has not yet paid at closing, and the seller has not yet transferred title. So the fact that the agreement is executory doesn't mean it's not binding. It just means that the performance is still outstanding. Um, the fourth is that the agreement is likely subject to formal or legal form requirements. Um, Real estate transactions do require written documentation. And the statute of frauds, it frequently applies to interest in land. The exact legal requirements, though, are going to depend on the jurisdiction, but a written signed agreement is definitely an important evidence of the bargain. And then you have the signatures, which are going to support our mutual assent. A signature is not always conclusive, but it is strong evidence that the parties accepted the terms. The contract should identify the property, the purchase price, the conditions at closing, any kind of contingencies, any kind of default provisions, any other kind of material terms. But this is an example of how the classifications kind of work together. The same agreement can be express, bilateral, executory, formal or subject to writing requirements, and enforceable. But each label is going to answer a different question about the transaction. Now, when reviewing a contract or contract back pattern, use a systematic checklist. First, identify your parties. Who is making commitments? Are they individuals, companies, agents, representatives? Who are they? Do they have the authority to even enter into the agreement? Second is to identify the offer and the acceptance. Where does one party, propose the bargain? Okay. Where does the other party show assent? Look for language such as, seller offers, buyer agrees, the parties agree. Those are, you can even have, like on electronic forms, you can have indicators like the signature blocks or the acceptance buttons. All of those things are going to point to being able to identify the offer and the acceptance. Third is to identify the consideration. What is each party giving or promising? Is there money, property, services, a promise to perform, a promise not to act, or another exchange of legal value? Fourth is to identify the subject matter and legality. What is the contract about? Is the subject matter described clearly? Is the purpose lawful? Fifth is to identify the conditions, the duties, and the remedies. Okay. What must happen before performance is required? What deadlines apply? What occurs if someone fails to perform? Does the contract address, default, damages, attorney's fees, insurance, dispute resolution, termination, things like that? Six is to identify evidence of assent. Okay. Are there signatures? Are there emails, text messages, purchase orders, invoices, any kind of conduct that shows that the parties have accepted the agreement? Okay. This checklist is useful because contracts are not always labeled clearly. So a document called memorandum or proposal or letter of intent or estimate, they may or may not be a binding contract. The title is relevant, but the actual language, the conduct and the legal requirements are going to control the analysis. So develop the habit of reading documents for legal function. Ask what each clause does and what legal issue it addresses. And that approach is going to help prepare you for a more advanced contract interpretation and drafting. All right, let's consider a restaurant customer who orders a meal, they receive it, they eat it, and they pay the posted price. This ordinary transaction can be classified in a few different ways. The agreement may be implied in fact. The customer doesn't typically sign a contract or negotiate every detail, but the customer's conduct, they entered the restaurant, they ordered from the menu, they accepted the meal, and they ate it. Those all objectively indicate an agreement to pay. All right. The restaurant's conduct, the preparing the meal, the serving the meal, it indicates the agreement to provide food and service. Okay. The transaction can also be analyzed as a bilateral or unilateral agreement, depending on how the offer and performance are framed. The restaurant offers to provide food at stated prices, and the customer's order and payment help to establish the bargain. The exact classification honestly may matter less than like recognizing that the party's conduct can create the legally enforceable obligation. um Once the restaurant serves the meal and the customer pays, the agreement is executed because both parties have performed. If the customer has ordered, catering for like an event next week and paid a deposit, then the contract would be executory because, again, we have future duties that remain. The agreement is informal because it does not require any kind of special formalities, but it can be, enforceable. The absence of a, lengthy written document or anything like that doesn't mean that the parties have no legal obligations. But again, this example is just to illustrate, the importance of not like um, equating contract law only with, a written agreement. Contract law governs many ordinary transactions that come up through routine conduct. The legal question is whether or not the parties objectively created an agreement that is supported by value and it's recognized by law. I'm just going to say that you can pause here and read. I'm not going to really go back and rehash. Um, I've said all of this stuff actually a couple of times because I was hoping to kind of drive it home. But again, pause to read. And that's it. We're at the end. I would say pause and kind of think about all of these, different questions right here. And down at the bottom, it gives you an exit task, which is to classify a contract from your daily life using at least three categories from this chapter. Um, you might use, and I'm not asking you to do anything with it, just kind of think about it in your head, but, think about subscription services, purchases, leases, employment arrangements, repair agreements, online orders, things like that. Think about whether it's express or implied. Is it bilateral or unilateral? Is it executed or executory? You know, is it informal or is it subject to a writing, requirement? But again, this exercise will help you to see that contract law, is all around you. That's one of the reasons why I think this is one of the most important classes that you can take. But again, we'll keep digging in and expanding on it because again, it is all around us and our lives are kind of ruled by contracts. That's it. If you have any questions for me, you know how to reach me. Bye.